If you do not have one specific document signed before you become incapacitated or pass away, your home may be required by law to pass through a court process that can take over a year, cost tens of thousands of dollars, and in some cases, force your children to sell the house just to pay for it. This is not a worst-case scenario. It is the default outcome, and the deadline to prevent it is not a date on a calendar. It is the moment something happens to you. Sit with that for a moment, not as an exaggeration, not as something that only happens to people with complicated finances, as the standard legal pathway written into the law of every state that a home follows when its owner dies or becomes incapacitated without one specific document in place. That pathway is called probate, and probate on average consumes between 3 and 8% of an estate's total value in court costs, attorney fees, and administrative expenses. On a home worth $350,000 that is between $10,500 and $28,000, money that comes directly out of what your children inherit, paid to a court process most families did not know they were entering. The average probate case involving a primary residence takes between 9 and 18 months to resolve. During that time, the home may not be sold, refinanced, or in some cases even maintained using estate funds without court approval. Families have lost homes to unpaid property taxes and lapsed insurance while waiting for a probate court to issue the orders that would have let them act. We are going to walk through 6 legal tools and documents related to how your home passes to your family, what happens without them, what each one actually does, and which one, in particular, elder law attorneys consistently describe as the single most important document a homeowner over 65 can have in place. That document, item number 5, is the one most families have never heard of, and the one that, when missing, causes the most damage at the worst possible moment. We will get there. Stay with us. Here is what you need to understand about how probate courts actually operate. When a homeowner dies without the right documents in place, the home does not automatically transfer to a spouse or children, regardless of what a will says, and even if there is no will at all. Instead, the property enters the probate court system, where a judge oversees the process of identifying heirs, paying debts and taxes, and eventually authorizing the transfer of the property. Probate courts were not designed to move quickly. They were designed to be thorough, to protect creditors, to resolve disputes among potential heirs, and to ensure the state collects any taxes owed before assets change hands. Thoroughness in this context means delay, and delay for a family trying to manage a home, a mortgage, property taxes, and insurance during a period of grief can become its own financial crisis. Banks will not release funds from the deceased's accounts to pay the mortgage without court authorization. Insurance companies may flag a policy as higher risk once they learn the named owner has passed and no transfer has occurred. Property tax exemptions tied to the deceased owner, including the senior exemptions we have discussed in previous videos, may be removed from the account, increasing the bill while the family is still navigating the court process. The probate court was not built to protect your family's timeline. It was built to protect the integrity of the legal transfer, on its schedule, not yours. Here are 6 tools that determine whether your home follows that schedule or bypasses it entirely, starting with the one most people believe protects them and does not. Tool number 1, the last will and testament, and the protection it does not actually provide. This is where almost every family starts, and it is also where the most dangerous misunderstanding in estate planning begins. A will is a legal document that states your wishes for how your property should be distributed after your death. It names an executor. It can name guardians for minor children. It can specify who receives which possessions. What a will does not do, and this is the detail that surprises most people, is transfer property automatically. A will is a set of instructions for a probate court. It does not avoid probate. It is the document probate courts use to conduct probate. Here is the dollar reality. If your home is titled in your name alone and your only estate planning document is a will, your home will go through probate regardless of how clearly the will states who should receive it. The average cost of probating an estate that includes a single family home ranges from $8,000 to $20,000 in attorney and court fees depending on the state and the value of the home. And this cost is paid from the estate before your children receive anything. Here is the detail most families miss. Many people believe that because they have a will, their home is protected and their children will receive it quickly and without cost. In reality, having a will simply means the probate court has clear instructions to follow. It does not change the fact that probate must occur or how long it takes or what it costs. A retired accountant in Pennsylvania had a will drafted in his 50s, naming his two adult children as equal beneficiaries of his home and savings. When he passed away at 78, his children assumed the process would be straightforward. The will was clear and there was no family disagreement. Pennsylvania's probate process for his estate took 14 months. During that time, the children paid the mortgage, property taxes, and insurance out of pocket because the estate's accounts were frozen pending court approval. Total out-of-pocket costs before the estate reimbursed them, $11,200. Total probate fees paid from the estate, $9,800. In Pennsylvania, Ohio, and New Jersey, states where probate courts have significant backlogs, the timeline for even uncontested estates with clear wills regularly exceeds a year. What to do? If your only estate document is a will, that is not a failure, it is a starting point. The question is not, do I have a will, but does my home avoid probate entirely, or does it go through probate even with my will in place? The remaining items in this video answer that question, and one of them in particular is the document most homeowners over 65 are missing. Tool number 2, joint tenancy with right of survivorship. The protection that works until it doesn't. Many married couples and some parent-child arrangements hold their home in what is called joint tenancy with right of survivorship. This is a form of property ownership where, upon the death of one owner, the surviving owner automatically becomes the sole owner of the property without probate. For married couples, this works exactly as intended in most cases. When one spouse dies, the surviving spouse retains full ownership of the home immediately, with a simple filing of a death certificate at the county recorder's office. No probate, no court delay. The cost to file the death certificate and update the deed typically ranges from $0 to $150, depending on the county. Here's where it stops working. Joint tenancy avoids probate at the first death, but it does not avoid probate at the second death unless a new joint owner is added or another tool is used. When the surviving spouse passes away, if the home is titled solely in their name with no further planning, the home goes through probate at that point, just delayed by one generation. Here is the second problem, and it is the one that generates the most family conflict. Some parents, attempting to avoid probate, add an adult child as a joint tenant on the home's deed, believing this transfers the house to that child automatically while protecting it from probate. This creates several unintended consequences. The added child becomes a legal co-owner immediately, not just upon the parent's death, meaning the child's creditors, divorce proceedings, or bankruptcy can now reach an interest in the parent's home. If there are multiple children and only one is added to the deed, that child may have no legal obligation to share the home's value with siblings, regardless of what the parent intended verbally, and adding a child to the deed can be treated as a gift for tax purposes, potentially affecting the child's cost basis and future capital gains tax when the home is eventually sold. A widow in Ohio added her oldest son to her home's deed as a joint tenant, intending for him to handle things and split the proceeds with his two siblings after her death, an arrangement they had discussed as a family. When she passed away, the home transferred to the son automatically, outside of probate, exactly as the joint tenancy was designed to do. The son experienced a contentious divorce 2 years later. His ex-spouse's attorney identified the home, now solely his, as a marital asset subject to division because it had been in his name for over 2 years. The siblings had no legal claim. The home was eventually sold as part of the divorce settlement, and the siblings received nothing despite their mother's verbal intentions. In Ohio, Michigan, and Illinois, states where adding a child to a deed remains a common informal estate planning method, elder law attorneys report that unintended consequences from joint tenancy additions are among the most frequent disputes they are asked to resolve after the fact. What to do? If you are married and your home is titled jointly with your spouse, confirm this with your county recorder. Many older deeds do not specify joint tenancy with right of survivorship explicitly, and without that language, the protection may not apply as expected. If you are considering adding an adult child to your deed as a probate avoidance strategy, stop and consider item number 5 instead, which accomplishes a similar goal without the risks just described. We have 4 more tools ahead, including the one most families have never heard of. Keep watching. Tool number 3, the transfer on death deed. Available in some states, unavailable in others, and frequently misunderstood in both. This tool sounds like it should solve everything, and in the states where it is available, it solves a great deal. But only if it is filed correctly, and only if you live in one of the roughly 30 states that currently recognize it. A transfer on death deed, sometimes called a beneficiary deed, beneficiary deed, allows a homeowner to name a beneficiary who will receive the property automatically upon the owner's death, without the property going through probate and without the beneficiary having any ownership interest, rights, or exposure while the original owner is alive. This addresses the central problem with joint tenancy additions discussed in the previous section. The named beneficiary has no legal interest in the home until the owner's death. Their creditors cannot reach it. Their divorce cannot touch it. The owner can sell the home, refinance it, change their mind about the beneficiary, or revoke the deed entirely at any point while alive, none of which is true once a joint tenant has been added to a deed. Here is the dollar comparison that makes this concrete. A home worth $320,000 transferred via transfer on death deed passes to the named beneficiary with a simple filing of a death certificate and an affidavit, typically costing under $200 in recording fees. The same home, passing through probate because no such deed was filed, costs the estate between $16,000 and $25,000 in fees and takes 9 to 18 months, a difference of tens of thousands of dollars and over a year of time for the same piece of property. Here's the detail that causes the most missed opportunities. Transfer on death deeds must be properly executed and recorded with the county before the owner's death. They cannot be created or backdated afterward. And critically, they must be drafted to comply with the specific state's statutory requirements. A deed copied from a template designed for a different state, or one missing a required witness or notarization element specific to the homeowner's state, may be rejected by the county recorder or successfully challenged after the owner's death, at which point the home falls back into probate after all. A retired nurse in Missouri completed a transfer on death deed, naming her daughter as beneficiary, using a form she found online that was designed for a neighboring state's requirements. The form was missing a specific attestation clause Missouri law requires. The deed was recorded by the county without issue. County recorders generally do not verify legal sufficiency at the time of filing. When the nurse passed away 4 years later, her daughter attempted to use the deed to transfer the home. An attorney reviewing the document identified the deficiency. The deed was deemed invalid, and the home entered probate, the exact outcome the deed was meant to prevent. The probate process cost the estate $14,600 and took 11 months. As of 2026, states including Arizona, Texas, Ohio, Illinois, Missouri, Colorado, and Washington recognize transfer on death deeds for real property, while states including New York, New Jersey, and Pennsylvania do not offer this specific tool, meaning homeowners in those states need to rely on other mechanisms, including the one in item number 5. What to do? Confirm whether your state recognizes transfer on death deeds for real property. If it does, this can be one of the simplest and lowest cost probate avoidance tools available, but it should be drafted by an attorney familiar with your specific state's statutory form requirements, not copied from a generic template. If your state does not recognize this tool, the next items in this video apply to you directly. Tool number 4, the durable power of attorney, protection while you're alive, but not after. Everything discussed so far addresses what happens to your home after you die. This tool addresses something equally important and often overlooked entirely. What happens to your home if you become incapacitated while you are still alive? A durable power of attorney for property names someone, your agent, to manage your financial affairs, including your home, if you become unable to do so yourself due to illness, injury, or cognitive decline. Critically, this document has no effect after your death. Its entire purpose is to bridge the gap between incapacity and death. A gap that, for many seniors, can last months or years. Here's why this matters specifically in the context of the home. If you become incapacitated following a stroke, a serious fall, or a progressive condition, without a durable power of attorney in place, no one, not even your spouse, has automatic legal authority to sell your home, refinance it, pay property taxes from your accounts if your name alone is on them, or access funds to pay for the care that might allow you to remain there. Your family's only recourse becomes a court-supervised guardianship or conservatorship proceeding, a legal process similar in cost and timeline to probate, except it happens while you are still alive, and the family is also managing your medical crisis. The average cost of establishing a guardianship or conservatorship over an incapacitated person's finances ranges from $3,500 to $15,000 in attorney and court fees, and the process typically takes 6 to 12 weeks at minimum. weeks during which bills may go unpaid and decisions about care and housing may be delayed. A retired teacher in California suffered a stroke at 74 that left her unable to manage her finances. Her home was titled solely in her name. Her durable power of attorney, drafted 15 years earlier, named her sister as agent, but her sister had passed away 2 years prior, and the document named no successor agent. Her son had to petition the court for conservatorship to access funds for her care and to manage the home. The process took 9 weeks and cost $7,400, paid from her savings during a period when those funds were also urgently needed for her care. In California, Florida, and Texas, states with large populations of seniors living independently, often at a distance from adult children, outdated or improperly structured powers of attorney are among the most common gaps elder law attorneys identified during emergency consultations. What to do? If you have a durable power of attorney, confirm 2 things: that your named agent is still living and willing to serve, and that you have named at least 1 successor agent in case your first choice cannot serve. If you do not have this document, it should be considered alongside, not instead of, the document we are about to discuss, which is the one most families have never heard of. And now, the document itself. Tool number 5, the Revocable Living Trust. The single document, elder law attorneys say, protects the home more completely than any other. This is the one. Of everything discussed in this video, the will, the joint tenancy, the transfer on death deed, the power of attorney, the revocable living trust is the document that elder law attorneys most consistently describe as the most powerful, most flexible, and most underutilized tool available to homeowners over 65. And it is the one most families have never been told actually applies to them. Here's the core concept. A revocable living trust is a legal entity that you create, that you control completely while you are alive, and that can own your home in its place. You transfer the title of your home from your own name into the name of the trust. For example, from John Smith to John Smith, trustee of the John Smith Revocable Living Trust. You continue to live in the home, sell it, refinance it, or do anything else you could do before. Nothing changes day to day. The trust document names a successor trustee, typically a spouse or adult child, who steps in automatically if you become incapacitated and who distributes the home to your beneficiaries after your death, according to the instructions in the trust, without probate, without a guardianship proceeding, without a court involved at any point. Here is what makes this different from every other tool discussed today. It solves both problems at once. If you become incapacitated, your successor trustee can immediately step in to manage the home, pay the mortgage, handle the property taxes, even sell the home if necessary for care costs, without a conservatorship proceeding. And when you pass away, the home transfers to your beneficiaries according to the trust's instructions, without probate, regardless of which state you live in, including the states where transfer on death deeds are not available. Here's the dollar figure that makes this the highest stakes item in today's video. Consider a homeowner with a $400,000 home, no trust, and only a will. Upon incapacity, a conservatorship proceeding costs an estimated $3,500 to $15,000 and takes 6 to 12 weeks. Upon death, probate of the estate costs an estimated 3 to 8% of the estate's value, between $12,000 and $32,000 on a $400,000 home, and takes 9 to 18 months. Combined, a family facing both an incapacity event and a subsequent death without a trust in place may face total costs between $15,500 and $47,000, and a combined timeline of court involvement spanning over a year, layered on top of the emotional toll of the events themselves. With a properly funded revocable living trust, both of these processes are bypassed entirely. The cost to establish a trust and transfer the home into it typically ranges from $1,500 to $3,500 with an estate planning attorney. A one-time cost. There is no ongoing court involvement, no conservatorship, no probate at either incapacity or death. Here is the detail that causes the most damage when missed, and it is the detail almost no one understands until it is too late. Creating the trust document is only step 1. The home must then be formally transferred into the trust's name through a new deed recorded with the county. This step, called funding the trust, is the step that gets skipped. An attorney creates a beautiful, comprehensive trust document. The homeowner signs it, feels protected, and the document goes into a drawer. The deed to the home is never changed. The home remains titled in the homeowner's individual name. And when the homeowner dies, the trust, despite existing, despite being signed, despite naming the children as beneficiaries, owns nothing. The home, still titled individually, goes through probate exactly as if no trust existed at all. A retired engineer in Texas worked with an attorney to create a comprehensive, revocable living trust at age 70, naming his 3 children as equal beneficiaries of his $380,000 home. He paid $2,800 for the service. The attorney provided the trust document and a checklist that included transferring the deed to the home into the trust's name. The homeowner, satisfied that he had done his estate planning, filed the documents in a drawer and never completed the deed transfer. He passed away at 81. His children discovered during the process of settling his affairs that the home was still titled in his individual name. The trust, 11 years old, perfectly drafted, owned nothing. The home went through Texas probate. The process took 13 months and cost the estate $19,400. His children later learned that the deed transfer his attorney had recommended would have taken approximately 20 minutes at the county recorder's office and cost $35 in recording fees. Surveys conducted by estate planning organizations consistently find that among homeowners who report having a trust, a significant percentage, in some studies exceeding 1 in 3, have never completed the funding step that actually transfers their home into it. The trust exists. The protection does not. In California, Florida, and Texas, states with high home values and correspondingly high probate costs as a percentage of estate value, the gap between an unfunded trust and a funded trust can represent the difference between an estate that transfers in weeks at minimal cost and one that loses tens of thousands of dollars and over a year to the probate court. Here is the deadline reality. There is no calendar deadline for this document. The deadline is the date of your incapacity or death, a date none of us know in advance. A trust created and funded today protects you starting today. A trust created but not funded protects no one, regardless of how long ago it was signed. What to do? If you already have a revocable living trust, call the attorney who created it, or any estate planning attorney, and ask one direct question. Is my home currently titled in the name of my trust, or is it still in my individual name? This requires only a look at your deed, which is a public record your attorney or the county recorder can verify in minutes. If your home is not yet titled in the trust's name, the deed transfer is a simple, low-cost fix, but it must be done. If you do not have a trust at all, consult an estate planning attorney about whether a revocable living trust is appropriate for your situation, particularly if you live in a state without transfer on death deeds, or if you have a blended family, multiple properties, or want to plan for incapacity and death with a single document. Tool number 6. The Beneficiary Designation Review, the small step that can undo everything else if it's forgotten. This final item is not a separate document. It is a review step, and it is the one that quietly overrides every other tool discussed today if it is skipped. Many of your most significant assets, life insurance policies, retirement accounts, payable on death bank accounts, transfer to beneficiaries by direct designation, completely independent of your will, your trust, or any deed. These designations were typically made decades ago, often when you first opened the account or purchased the policy, and many people never revisit them. Here is why this matters in the context of your home specifically. If your estate plan relies on your trust or your will to direct how your assets, including funds that might be needed to maintain or pay expenses on the home, are distributed, but a major account still names an outdated beneficiary, that account bypasses your entire plan. It goes directly to whoever is named, regardless of what your trust or will says and regardless of your current wishes. Here is the real-world consequence. A retired accountant in Florida updated his will and created a trust at age 72, naming his current wife, his second marriage, as primary beneficiary of his estate, with the home eventually passing to his children from his first marriage after her death. He never reviewed the beneficiary designation on a $180,000 life insurance policy, which still named his first wife, divorced 22 years earlier, as primary beneficiary. The divorce decree had addressed the marital home, but had never specifically required the insurance beneficiary to be changed, and no one had ever updated the form with the insurance company. Upon his death, the $180,000 policy, which his current wife and children had assumed would be available to help cover the mortgage on the family home during the trust's administration, was paid directly to his ex-wife in accordance with the decades-old form on file, regardless of what his will or trust said. In Florida, Texas, and Arizona, states with high rates of remarriage among retirees, outdated beneficiary designations on life insurance and retirement accounts are among the most common sources of family conflict and unintended outcomes that elder law attorneys encounter, often surfacing only after the original account holder has passed away and cannot correct the error. What to do? Create a list of every account and policy you hold that includes a beneficiary designation. Life insurance, IRAs, 401ks, annuities, and any payable on death bank or brokerage accounts. For each one, call the institution and confirm who is currently listed as primary and contingent beneficiary. If any of these designations were made before a divorce, remarriage, death of a previously named beneficiary, or any other major life change, update them immediately. This review typically takes one afternoon of phone calls and costs nothing. Here is what you do this week. Step 1. Locate your current estate planning documents, will, trust, power of attorney, and identify what you actually have. If you cannot find these documents or are unsure whether they exist, contact the attorney who may have prepared them or check with your county recorder for any deeds filed in a trust's name. This costs nothing and takes about 30 minutes. Step 2. If you have a revocable living trust, verify whether your home is titled in the trust's name by checking your deed. Your county recorder's office can confirm this, often through an online search, for free. If the home is not yet in the trust's name, contact an estate planning attorney to complete the deed transfer, typically a $200 to $500 cost and a same-day or same-week process. Step 3. If you do not have a trust and live in a state that does not offer transfer on death deeds, schedule a consultation with an estate planning attorney to discuss whether a revocable living trust is right for your situation. Initial consultations typically cost $0 to $300, and a complete trust package, including the deed transfer, generally ranges from $1,500 to $3,500. Expected time, 2 to 3 appointments over 4 to 6 weeks. Step 4. Review and confirm your durable power of attorney names, a current willing agent, and at least one successor. If your document is more than 5 to 10 years old, or if your named agent has passed away, moved, or is no longer willing or able to serve, this should be updated alongside your other documents. Expected cost, if done with your trust attorney, often included or available as a low-cost addition. Step 5. Call every life insurance company, retirement account custodian, and bank holding a payable on death account and confirm your current beneficiary designations. Update any that reflect outdated relationships or circumstances. This step is free and can typically be completed over the phone or through an online portal in one afternoon. You worked your entire life for that house. You raised your family within those walls. You made the payments, weathered the hard years, and built something that was always meant to pass to the people you love, not to a courtroom and not to a list of fees. The probate system does not know your children. It does not know that they are grieving, that they are managing your final affairs alongside their own jobs and families, that every month of delay is a month of mortgage payments and property taxes coming out of their own pockets while they wait for a judge's signature. The system simply processes, on its timeline, at its cost. Your spouse should not face a conservatorship proceeding because a power of attorney names someone who is no longer there. Your children should not lose a portion of this home's value to a court process that a single document, properly created and properly completed, could have avoided entirely. The trust, the deed transfer, the beneficiary review, these are not complicated. They are paperwork. And that paperwork is the difference between a home that passes to your family the way you intended and a home that spends a year and tens of thousands of dollars proving that intention to a court. Take action this week. Protect what you built. If you know someone over 65 who has a will but has never confirmed whether their home would actually avoid probate, share this video with them today. It may be the most valuable conversation they have this year. Next week, we are covering the Medicaid 5-year look-back rule and the specific transfers that can disqualify your family from coverage at the exact moment you need it most. You will not want to miss it.